Good afternoon, ladies and gentlemen. As you know, we're here on a couple of motions to compel filed in the Melody Tune versus Starbucks case. Both sides have asked for certain documents or information in discovery, to which the other side has filed or has objected to providing. Thank you for submitting your arguments. I've had a chance to look at through your motions to compel and considered your oral arguments in this case. I want to first rule on Starbucks' motion to compel from Ms. Toon a copy of a lawsuit she filed in 2008 against Lava, Fire, and Wax, along with the supporting medical documentation for that lawsuit. First, the plaintiff has objected on the grounds that this request is cumulative and overbroad, and I just don't find that to be true. The defendant's very specific in its request and did not ask for all the pleadings, didn't ask for anything other than the lawsuit and the medical records, and then we had the objection. The plaintiff further objected that the production of this discovery request would not likely lead to evidence that would be admissible at trial. Rule 26B1 of the Federal Rules of Civil Procedures, where in district court, states that parties may obtain certain discovery regarding any matter that's not privileged, that is relevant to the claim or defense of the party. And then it goes on to define relevant information need not be admissible at the trial if the discovery appears reasonably calculated to lead to the discovery of admissible evidence. And information within the scope of discovery need not be admissible in evidence to be discoverable. So in that case, the case of Coleman and the American Red Cross, which is a federal case in the Sixth Circuit in 1994, stated that the scope of discovery lies within the sound direction of the trial court. So in this case, I'm going to allow the discovery request for Starbucks in order that Ms. Toon provide the information requested prior to related to her prior lawsuit, including the medical records that she used to support the lawsuit as set out in the interrogatories. Now, as to Ms. Toon's motion to compel certain documents from Starbucks, first, the plaintiff has requested records of orders of protective lids for 4 weeks, for a 4-week period. And though I don't find this request to be overly broad or unduly burdensome as it is specific, I do not see that the production of these records is relevant to this case, or that it could lead to any evidence that is admissible at the trial. So therefore, the request for records as to the protective lids is denied. As to the video footage, I don't find this request to be overbroad or burdensome, because the plaintiff has requested a certain amount of time in the video. She's asked for 12 hours, and so, and again, I'll refer back to Rule 26B1 that this could lead to something that's relevant to the case, and so the request for the video footage for the 12 hours is granted. And then finally, the request for the temperature setting history on the machine that brewed the coffee that was served to Ms. Toon. The defendant objected that this request is overbroad and overburdensome, and I agree with the way this request is written that it is. However, I will allow that the request for the temperature setting history, there's no time frame that the defendant requested. So I'm going to allow those records to be produced. I'm going to order that those records be produced, but limit that to the 7 days immediately prior to and leading up to the day of the accident, including the day of the alleged injury, to the close of business. So for 7 days leading up to the accident, including the day of the injury and to the close of business, and including footage that includes the drive-through. So, I'm going to allow that with that modification. So I believe that addresses all the issues before the court in this matter. I'll ask that each of you attorneys prepare your own orders so as to keep the court's records, maintain clarity in the court's records. And I'll direct the clerk that any cost associated with this case or with these motions be equally divided between the parties. And if there's nothing further, we'll consider ourselves adjourned.